Hello friends, in this lecture we are going to discuss mock test with explanation relating to JIB, legal and regulatory aspects of banking. So here we have certain questions which we shall discuss along with explanation. First question, which of the following is not power of Reserve Bank of India under Banking Regulation Act as a regulator and as a supervisor of banks? We have the following options: to issue license for opening of a bank, to regulate cash reserve and statutory reserves, to undertake audit and inspection of banks, to give directions in public interest. Friends, Reserve Bank of India exercises various powers under Banking Regulation Act as a regulator and supervisor. It issues license, it undertakes audit and inspection, it gives direction, but as regards cash reserve, that is CRR, that is not regulated under Banking Regulation Act, that is regulated under RBI Act. Hence, this is our answer. So RBI has a number of supervisory and regulatory functions as given in various options. But regulation of CRR is through RBI Act and not through Banking Regulation Act. Hence, this is the answer. Question number 2. If the banking license of a company is cancelled, the appeal can be made by that company to whom and within how much period from date of order rejecting the license? Let us see the option. High Court within 30 days. Supreme Court within 30 days. Central government within 30 days. Central government within 60 days. When Reserve Bank of India cancels the license of a banking company, it can make appeal to central government and time limit is 30 days. So a banking company can appeal to central government within 30 days from date of order of rejection. Let us see next question. If a chairman of a bank is removed by Reserve Bank of India, he can appeal to whom and within how much period? Let us see the answer. Let us see the options. First option, to Governor RBI within 30 days. To SEBI within 30 days. To central government within 30 days. To central government within 2 months. Friend, whenever Reserve Bank of India removes chairman of a bank, then that person can make appeal to central government within 30 days. Hence, C is our answer. The appeal can be made by the chairman of a bank who is removed by a Reserve Bank to central government within a period of 30 days of date of order. Let us see question next. Which of the following provides that a transaction between a banking company and its borrower cannot be reopened by courts on the ground that rate of interest is excessive? So there are certain instructions, certain rules which courts cannot question, cannot reopen. So which of the following provides that a transaction, let us say a loan, between a banking company and borrower cannot be questioned by courts on the ground that rate of interest is excessive? Section 12 Usurious Loans Act. Section 46 Reserve Bank of India Act. Section 21A Banking Regulation Act. Section 21 Banking Regulation Act. Friends, if a bank follows RBI guidelines in fixing rate of interest, Section 21A Banking Regulation Act provides protection to that bank that the rate of interest being excessive cannot be challenged in a court. Section 21A Banking Regulation Act provides that a transaction between a banking company and its borrower cannot be questioned in the court on the ground that rate of interest is excessive. Hence, our answer is C. Indian banks are required to transfer how much percent of their annual profits to reserve fund under Banking Regulation Act? Let us see the options. 25%, 20%, 15%, 10%. Friends, Section 17 Banking Regulation provides that banks have to transfer at least 20% of their annual profits to reserve fund called special reserve fund. Hence our answer is B. Banks incorporated in India are required to statutorily transfer 20% of their profits every year to a reserve fund. So this requirement is of Section 17 Banking Regulation Act. The liquid assets under Section 24 Banking Regulation Act can be amended by bank in the form of liquid assets under Section 24 can be maintained by a bank in the form of A. Cash in hand and bank balances only. B. Cash in hand, bank balance, investment in gold or approved securities. Cash in hand, bank balance, investment in gold only. Cash in hand, investment in gold and approved securities only. Friend, here we are talking about SLR. SLR can be maintained by the bank in the form of cash in hand or bank balance or investment in gold or approved securities. Hence, our option answer is B. Under Section 24 Banking Regulation Act, which relates to SLR, the liquid assets, that is SLR securities, can be maintained as cash in hand, bank balance, investment in gold, approved securities. In case of nomination for bank deposit accounts, the nominee can obtain payment of deposit. Let us see the options. Before maturity in case of a term deposit. During the lifetime of the depositor. Even when there is a direction from court to the contrary. Give discharge on FDR for raising a loan after death of the account holder. So, which one of these is correct? In case of nomination for deposit account, the nominee, he can obtain payment before maturity in case of term deposit but after death of the customer. During the lifetime of the depositor, no, he has no right. Even when there is direction from court to the contrary, no. If there is direction from the court, that direction has to be followed. Give discharge on FDR for raising loan. No, he cannot give discharge. So the only answer which is correct, he can obtain payment before maturity but only after death of the customer. So the nominee can obtain payment of FDR before maturity but cannot give discharge for obtaining loan. If there is a court order, payment to be made as per court order. Further, during lifetime of the account holder, he has no right relating to the deposit account. A banking company has to prepare the balance sheet. Let us see what are the options. In the form prescribed by Reserve Bank of India, in the form prescribed by central government, in the form set out in third schedule of Banking Regulation Act, in the form prescribed by Institute of Chartered Accountants of India. So what are the provisions regarding banking companies' balance sheet? Friend, banking companies have to prepare balance sheet on a format which is prescribed under third schedule of Banking Regulation Act. Hence, our answer is C. A banking company has to prepare the annual accounts, profit loss account and balance sheet in the form set out in third schedule to the Banking Regulation Act. Hence, answer C is our answer. Well friends, we shall continue with such multiple option questions in next lecture also. Thank you.